know it's not your job. But if we want to put a can outside the door here, and that way, if you need to do something, you can just get up and you have my permission to get up and leave and just go through that door.
Thank you so much.
Do not head towards the court reporter.
Oh, no,
No, she's
no.
right there.
I would know.
Do not
That's the
put
last thing
anything
I
on
wanna
the
do
court
is make
reporter.
anybody
Wait.
else.
You want me to get you down?
Yeah.
No.
So it's right outside that door and you can just, so state defense, if he needs to run outside the door, I'm giving him permission to run outside the door. All right, so you are still under oath and you may continue with your questioning. And I think you were publishing.
Yes, Your Honor. Exhibits. Write down the number of things. Something important that here comes out. And Your Honor, maybe approach just.
Yes. Can you mute us, please?
You need me? Yes, just. How about that? We patch you out. We compliment each other. The state's exhibit 26. See what? State's exhibit 26, 26. Make sure the volume is.
Walking aggressively with the fucking knife, just like you're doing me.
From the building.
There's some rules about that, but you are. It's super close to the house call. It's right here, scared. That's stuff right now. Yeah.
And Your Honor, can we invoke the rule at this time?
All right, the rule is invoked. If there's any witnesses who are going to testify in this bench trial, you need to leave the courtroom and they will call you as needed. Are you here for this case, Miss?
Yes.
All right, is she going to be testifying?
I don't know yet, so I guess we better place her outside.
All right, can you come forward for me, please?
Pretty dead tricky.
All right, and just give us one moment. All right. State, you may continue.
You saw the video we just watched. Where was that in the house?
Oh, that's my bedroom.
Okay.
My bedroom and then like the kitchen areas where we ended up at the end.
Okay, I'm gonna need you to keep your voice up.
That was my bedroom and we ended up in my kitchen area at the end.
Um, Please states exhibit 29.
20 what?
29.
29. Thank you.
She doesn't look dull. She doesn't, because if she did, she wouldn't be doing what she's doing. She made herself better. When I have tried.
Was that where
to myself better, I was there. I tried to fix my problems. She doesn't.
That's not much.
She just wants to fucking. So what? Like you're safe right now? Yeah, you don't feel like you're safe right now? No, you don't feel like you're safe. You feel like you're safe?
Um, so what part of the house were you in on that part of the video?
I was in my living room
Okay.
and
And
we spilled out outside.
okay, so you from the living room to outside.
Correct.
Um, was she threatening to use the knife on you?
Yeah.
What was the emotional state of your children when she was doing that?
Objection. That calls for a conclusion.
That'll be overruled. You can answer if you know.
I honestly just think they didn't really know what was going on. It was a lot for them to handle at the time. So I don't, I guess shock would be a good way to explain it.
Okay. Could you tell whether she was wearing her glasses in that video?
In that video, no, she did not appear to have her glasses on to me.
I'm gonna play State's Exhibit number 25.
Yes, ma'am.
And what part of the house were we just looking at?
That was the living room. That was the camera that I have in my living room. I'm sorry, that was the living room. That was the camera I have in my living room.
And was that some of the same, like a different angle of what we
That
were?
was exactly, it was the same footage, just from a different angle.
State's Exhibit 28. Sorry, I meant to pause it, but did you hear what she said in that moment? Or on the video?
Me?
Did you hear what she
Yes,
said? in that
yes.
moment? What did?
All
she
right,
say?
just 1 second. So y'all remember one at a time. Okay.
My apologies.
No.
Yes, I did.
Do you know what she said?
It sounded to me like she said, I'm not gonna kill them, I'm gonna kill you.
Who was she referring to?
She was referring to me and my children, not killing them, but killing me.
Okay. Um, so in that moment, was it a stressful moment?
To say the least, yes,
Tensions were high.
yes.
Did you say you were talking always in a calm tone?
No,
Um, Before, or when she was chasing you around with a knife, did she say anything?
that she was gonna kill me.
Do you know who your daughter was calling?
I assumed she was calling my dad, her grandfather. That's, he lives about 5 minutes away from me. He's usually kind of a peacekeeper.
Did her grandfather show up shortly after that?
Yes, but he showed up after the cops did.
Throughout the course of all of this, Did you ever hit her or strike her even in self-defense?
Yes, I did.
Um, how did you hit her? What were the circumstances?
It's actually in the video. It's when she was chasing me with the knife and my children were in front of me and they weren't. I mean, it's not their fault, but they weren't. I couldn't get out of the way fast enough and she got close enough to where I felt like I needed to defend myself.
Did you use an open hand or a closed hand?
It was probably closed hand, but it sure wasn't closed hand. It was kind of just a get away from me kind of thing.
On that day, April 2nd, 2023, did you strike her at any point before she pulled out the knife?
No,
Did you threaten her
no.
before she pulled out the knife? Did you?
Well, I tried to call the police. That,
Okay. Did you make any violent threats?
no,
Did you do anything violent towards her?
no, defend myself. That's it. No, all I did was defend myself the entire day.
Before she pulled out the knife?
Before she put out the knife, I was still defending, so she was still aggressive and trying to fight me competitive.
Okay, let's be clear. But before she pulled out the knife, did she do anything violent?
She was attacking me, yes. That's
And-
where I got a lot of the scratches from.
Okay. Do you think any of the scratches might have come from the knife too?
I don't believe so.
Okay. And did y'all fight over the knife?
No,
Okay. When you learned about her situation, everything that was going on the night before with her sister, with her mother, did you want to try help her?
that was my intention, yes.
Okay. Were you doing what you thought was the best course of action in that situation?
At that moment, yes.
And looking back on it, would you have preferred that she not come over to your house?
100%, yes.
Had she ever done something like this before?
This is not the first time.
Had she ever taken out a knife on you before?
Yes,
And did she have these, episodes of extreme mental distress?
yes.
Pass the witness.
No question.
Defense. All right. Is this witness excused or subject for recall?
You just want to say,
Yeah, as long as he's subject to recall.
All right. So if you'll make sure that you're available in case the defense wants to recall you, just make sure you're within 20 minutes of the courthouse. All right, thank you. The rule has been invoked. That means you can't discuss your testimony with anyone. The only persons you're allowed to speak to are, of course, your attorney and attorneys for the state of the defense. Do you understand?
Yes, ma'am.
All right, thank
And
you.
then, how long did you need me to stick around?
About 20 minutes. State,
For 20 minutes?
just 1 second. State, do you have any more witnesses after this witness?
no, Your Honor, the state has no more witnesses.
All right, so probably about 15, 20 minutes out in the hallway.
Sounds great.
Thank you.
Thank you.
All right, state, do you rest?
The state rests.
Defense. All right, can you mute us for a moment? Oh, you can just hand that to me and I'll have them file it. Are both parties ready?
Yes, Your Honor.
All right. All right, defense has filed a motion. Defense is asking for an acquittal. And so state, you have rested, and state, I'll hear your argument.
Your Honor, state's
Oh, please
argument-
remain seated.
Oh, okay.
Yes,
May we approach with case law?
yes. And did you tender case law copies to the defense?
Yes, we did.
All right, thank you.
At the Johnson case?
Yes.
That is exactly right. Thank you.
All right, thank you. All right, court, we're here, argument.
So in Johnson, Your Honor, the court refers to non-statutory allegations and it makes a distinction between allegations in an indictment that are required by statute and allegations in an indictment that are what they would call non-statutory allegations. And the court goes into detail and, you know, and notes that the language in the indictment, if it's an immaterial variance, the offense can still be proven with, even though there's an immaterial variance. And in that case, the state had alleged that the victim had been hit with the hand, and the state wound up proving that the victim had been thrown against a wall to sustain the injuries. And the court still ruled that was sufficient because the exact way that the injury is caused is immaterial to the level of the offense. And the reason why is under the statute, aggravated assault can be committed in two ways. One, an assault causing serious bodily injury, or an assault where someone, the second way is an assault where someone uses or exhibits a deadly weapon during the commission of the assault. Take note that the statute itself does not require the injury to be caused by that deadly weapon. The statute only requires that a deadly weapon be used or exhibited during an assault, and the injury can come from any other way, regardless of the deadly weapon. So it's the state's argument, and we're citing to the Texas Court of Criminal Appeals and Johnson v. State, and I'll quote them: "The precise act or nature of conduct in this result-oriented offense is inconsequential. Had the state pled and proved different injuries, a question might arise as to whether the difference between what is pled and what was proven was significant enough to be material. Separate crimes of aggravated assault could be based upon separately inflicted instances of bodily injury." So that's a quote from the Texas Court of Criminal Appeals, and Your Honor, I think we have provided a legally sufficient case under the way that this case is indicted.
All right, defense.
Howdy, Your Honor. First of all, Officer De Hoyos mentioned that at the scene, the complainant said he was not cut and he was not stabbed. And then when the complainant testified, one of the first things he said, he was not touched by the knife. And then towards the end, he was asked about the scratches and where I got the scratches. Well, that was before the knife was even used or exhibited, where I got the scratches. And he was directly asked by the prosecutor, were those scratches caused by the knife?
And I'm sorry, Mr. Steinberg, could you make sure that you speak up so that the court reporter can hear?
That seems fair. Thank you very much. Did I reiterate?
Yes.
The complainant, according to Officer De Hoyos, said he was neither cut nor stabbed. I could have used the improper language for me. Anyway, neither cut nor stabbed, just threatened. And then when the complainant started testifying, he started off with, "I was not touched by the knife." That was pretty soon in his testimony. Later on, he's testified as far as the scratches, they were not from the knife. And where, what the videos do not show, but the complainant pointed out, this started in the bedroom. And that's when the scratches were, when they were wrestling. Well, they don't have video in the bedroom. So that's where the scratches came from. But the point being is, the indictment is very specific. Caused bodily injury to him by cutting and stabbing with said deadly weapon. There was no cutting and no stabbing in any way, shape, or form, and the deadly weapon caused no damage whatsoever. And this is what he is charged: aggravated assault with a deadly weapon. They have not proven that. They've alleged it and not proven it, and I'm asking for an acquittal.
All right, State? Anything to add?
Other than, the state would again point to Johnson v. State and would also say at the proper time, the state will be asking the court to consider a lesser included charge of
No.
assault. bodily injury.
We
Yes.
object to any lesser included charge. No way.
No, I mean, you can make your objection, but the no way part,
Okay.
that's not
Or
in your purview.
emphatically object.
Yes, you can emphatically object to a lesser included, but the no way, that's for me to decide if
Yes,
it's no way. All right, so State, you're asking for a lesser included,
Yes, Your Honor.
and what lesser included are you asking for?
Assault bodily injury.
Okay,
If the court makes a finding of family violence, I can, the evidence is there for that.
okay. All right. Defense, since this is your motion, I'll give you the last argument.
Okay, well, we're going, if they're going to request a lesser included offense, the statute, it says, you know, Article 2810 and says that they cannot do that if I object, and obviously I object. And also with respect, this is an indictment returned by a grand jury. And I don't think without my consent, we can have a lesser included charge. I do not consent. We're entitled to have a grand jury determine whether or not my client should be indicted with any other case other than what is alleged in the indictment. And I cite you Sanders v. State, 978 Southwest 2nd, 597, and that's in the 2022 Texas Criminal Codes Plus on page whatever 324.
Okay. All right. I've heard everyone's arguments. If you all will wait a moment and I'll give you my ruling. But if someone could call up Mr. Cox, I know he's outside, I think, and we're going to take up this other bench trial, then I'll come back with my ruling on this case. And if I decide to rule against you, the defense, I should say, make sure that if you have any witnesses, you have them ready. Okay? So we're going to take a break on this and the court will come back with its ruling and we're going to bring Mr. Cox in. And I'm breaking with you all because I know on Mr. Cox's case, I think they have a trial. They're out deliberating. So I want to make sure that we finish all the testimony in this case. Okay,
Thank you, Judge.
thank you. So counsel, if you will pack up from that table.
Okay.
Can you mute us? We're going to go on a sharp break to get Mr. Cox and his client.
Judge, I don't have his number.
Oh, yeah. So are you guys ready?
Well, I'd like to,
No, I'm gonna give you your chance to do. Okay. So we are back on the record in 2023 CR 5150, State of Texas versus Genevie Lopez. And my understanding, the defense would like to make an argument. Is that correct?
yes, and
All right, you can remain seated.
we'd like to have the court consider the due process clause of the Fifth and 14th Amendment of the United States Constitution, the due course of law under the Texas Constitution, Article 1, Sections 13 and 19, and Texas Code of Criminal Procedure, Article 1.05. And in that respect, we also, I mean, it's basically, my client was asking me, what does due process mean? It's fundamental fairness. Fundamental fairness means you got a right to know what you're being charged with before you go to trial. And you got a right to defend against that. And I told my client, and in my belief, Your Honor, when they're talking about causing bodily injury by cutting and stabbing with said deadly weapon, which was a knife, I have a right to defend against that. They alleged it, they have to prove it, in my opinion. And that's it. I asked for an acquittal again.
All right. So defense, it's my understanding, because I want the record to be clear, with regards to the charges of aggravated assault with a deadly weapon, you're asking for an acquittal without putting on any testimony, and it's not your intent to putting on any testimony. Is that correct?
At this time, correct.
All right. No, I just want the record to be clear, because it's slightly different because we are in a bench trial. If we're in a jury trial, things would, of course, proceed in a different manner. All right. Defense, I have a question for you. Are you saying by your argument then that in felony cases and in felony jury trials, no one should ever be allowed to ask for a lesser included, or the state should never be allowed to ask for a lesser included offense?
No, they can ask whatever they want, and that's up to the defense attorney whether or not to allow that to happen. And sometimes as a defense attorney, you would like a lesser included charge. Because it gets another bite at the apple, maybe your client will get away, but without the lesser included offense, if I object, and I think Article, what is it, 2810 of the Texas Code of Criminal Procedure, I have a right to object.
No, I appreciate your objection. I want to make it clear, everybody, you have the right to object to whatever you would like to object to, and I'll just make a ruling. So yes, you have a right to object.
Yes.
This was just a question I had of you, counsel. Okay. All right. State, with regards to the lesser included request, the defense is arguing against that, and he's stating under due process rights.
Your Honor, I think under due process, the defense still has time to prepare for any lesser included counts. They're on constructive notice of everything that's being alleged in the case, and it's clear in the allegations and in the offense report and in the discovery that defense was on notice of everything that was alleged. The complainant's testimony is not really much different from what was in that evidence, and defense had notice and those allegations.
All right. And with regards to the complainant's testimony, was that what the complainant has testified to? Was that in the prosecution guide?
I did review the prosecution guide, Your Honor, and it did say that he was scratched by the defendant.
All right.
It was scratched by the defendant.
And the
But not by the
prosecution?
knife.
No, just 1 second. I'll allow you to continue your argument. And the prosecution guide, was that given to the defense?
Yes, that was provided in discovery to defense, and the defense signed the discovery acknowledgement.
All right. And that was provided before today. Am I correct in assuming that?
Yes, Your Honor, long before today.
All right. All right. So defense, you wanted to respond?
I am very unclear about what I'm supposed to respond to.
No, I mean, you wanted to respond mid-argument from the state, so I'm just giving you a chance to whatever you wanted to say.
We were not charged with scratching with our hand. In
Mhm.
that case that they cited, the Johnson case, if you use your hand to push, hit, or pull somebody, that's probably, that's my understanding of the Johnson case, not a change, but that article 2810 and the cases cited talk about, let's say, section C, may not be amended over the defendant's objection as to form or substance if the amended indictment or information charges defendant with an additional or different offense, or if the substantive rights of the defendant are prejudiced. Obviously, we're objecting. I came prepared to fight about whether or not she used a deadly weapon
Okay.
and whether or not she cut or stabbed somebody, not whether or not. And I'm pretty sure that the record will reflect the complainant said he was scratched before they went into the living room, before the knife.
All right. So, any further argument? Because I always want people to have, you can have your last arguments and then the court is going to make its ruling.
The state just wants to respond to that last thing the defense said, and that this was the same course of conduct. So even if she scratched him and then she grabbed the knife, it's all the same course of conduct and the same assault. And I will point the court to the Johnson case, because defense mentioned, well, Johnson mentions an assault with the hand, and then they proved a different assault with the hand, but the court clearly says that this is a result-oriented offense. So the exact act that caused the result is inconsequential. And it specifically said, had the state pled and proved different injuries, then there may be a question that arises. The state isn't arguing different injuries. We're all talking just minor scrapes and scratches. It's just a question of how those scrapes and scratches were sustained.
All right. So this is going to be the court's ruling. Just so the record is clear, because we're doing a bench trial and not a jury trial, if we were doing a jury trial, steps would be different. So with regards to the defense's request for an acquittal on the aggravated assault with a deadly weapon, the court will grant that. With regards to the state's lesser included offense, the court will find the defendant guilty of the lesser included offense of assault, bodily injury, family. Is there anything else? State defense, do you have any witnesses to present with regards to your case, or are you resting?
I guess I'm confused again.
All right, well, let me unconfuse
Because I
you.
think you've
Let me
already found
unconfuse
that
you.
I'm guilty.
No, let me unconfuse you. With regards to the aggravated assault with a deadly weapon, the state asked that a lesser included offense be included, correct? So with regards to the lesser included offense, the court is allowing the state to approve on the lesser included offense. I've explained, because we're doing a bench trial and not a jury trial, things are slightly running differently. If we're in a jury trial, you would ask for your acquittal. The state would say, we want a lesser included offense as well. And then the court would say, all right, the court is going to grant your not guilty verdict or acquittal on the aggravated assault with a deadly weapon. Then we'd move on to other things with regards to your case in chief. But because this is a bench trial, things are flowing differently. So far, since you have not presented any evidence whatsoever, which is your right not to, if we just stop the trial, this bench trial right now, it is a not guilty verdict on the aggravated assault with a deadly weapon, and it's a guilty verdict with regards to the lesser included offense. But if you're planning to present evidence as it relates to the lesser included offense, the court will hear that. But it would not make any sense for we to go forward with a bench trial and for me to say, oh, I'm giving you the lesser included offense of injury, bodily injury, but I'm finding that not guilty, but we're still going to go forward. You see, so I have to let you know that one, based upon the testimony that they've just been given, they do meet the elements. Whether or not your client is technically guilty or not guilty of those elements, I haven't received anything else. And I want to make sure that you realize that I know the burden never shifts from the state. It doesn't shift to you. But so far, it's a not guilty on the aggravated assault with a deadly weapon. With regards to their lesser included offense, just with them presenting their case, you haven't, presented anything, which you don't have to. They have met the elements. Now, I don't know if there's self-defense issues. I don't know if anything else of that nature would come up, but I am going to allow them to have their lesser included offense of assault, bodily injury, family.
And I would like to request, first of all, please note my exception.
Oh, please have a seat. You don't have to stand.
Okay, please note my exception to the ruling, but as an officer of the court, I've got to now proceed based upon your ruling without waiving my objection to.
Oh, no, I understand, but I wanted you to let you know that they met the elements of the lesser included offense.
Assault bodily injury. If I was in misdemeanor court and I was charged with assault bodily injury, I would come back with a request. How? What?
Mhm.
Are they?
And I think they've addressed that through their complaining witness.
Well, he mentioned something in the bedroom before the knife. Is that what we're talking about?
All right. So, counsel, what I can tell you is I listened to the testimony of the complaining witness, and based upon what the complaining witness has said, what I'm telling you is the elements to assault bodily injury have been met by the complaining witness's testimony. Now, I will keep an open mind if you want to present something, but I want the record to be clear that I am not shifting the burden to the defense. I'm not asking you to present anything. I'm just letting you know that if nothing is presented, then the lesser included offense, the court is going to find guilty on the lesser included offense. Do you understand what I'm saying? Because if they offered the lesser included offense and I was going to say lesser included offense, the person is not guilty, then why we're here. So I have to let you know they have met the elements for the lesser included offense of assault bodily injury. I understand that you want to retain your objections, with which the objections have been made on the record, and the court understands that, and those objections will be there.
Okay, so my question is, and you've got to understand, sometimes I think I'm dense. I
You are
really do,
not.
because I would like to know what were assault bodily injury. If that was the only allegation against my client in a misdemeanor court, I would want to know, okay, how, what? Are they complaining about her scratching him? Then I would have a self-defense to that. I'd just like to know what I'm being held to defend against.
All right. What I can tell you is I've listened to the testimony of the complainant. What the complainant has testified to in the court's eyes, it has met the lesser included offense of assault bodily injury. Now, if you want more information than that, then that's for appeal or whatever. But what I'm telling you is listening to that witness testify. The witness did testify that there were injuries, and those injuries were scratches.
Yes.
So,
Okay.
I mean, that's an injury.
As long as I understand that's what I'm defending against,
Yes.
we're ready.
Oh, you ready?
We're ready.
All right. So,
Unless you want to reset that for another day.
no, we
Okay,
will
we're ready
finish
on
this.
that.
Yes. All right. So that's the court's understanding from the witness's testimony that there were scratches,
Yes.
and those scratches were not caused by the knife.
They were
those-
before the knife.
Yes. So, Mr. Stenberg, if you would like to call witnesses, you're more than welcome to do so. If you would like to rest and close at this time, you're more than welcome to do so. If you would like to start with your opening statement, it's completely up to you.
Oh, I'm so glad.
All
I
right.
am ready.
You're ready?
Yes, sir.
All right. Do you have an opening statement?
Yes, sir.
All right. You may proceed, and you can remain seated if you wish.
This was a course of conduct over several years. Genevieve, if I may call her Genevieve, Miss Lopez has been abused by this gentleman for literally years. We have photographs, and I'm going to show them to the court. And he's threatened to kill her multiple times. And we have at least one of them in a text from him that he would like to kill her. And what happened in the bedroom was a self-defense issue. And what we intend to show the court is that she being Genevieve, was suicidal. She called him Robert, and he paid for an Uber or whatever it was to get her over there. And she had $2,000 in some account, and she said she was going to kill herself. So he knew how despondent she was and suicidal she was. And she sent him $2,000 via however they do it nowadays electronically, immediately, because she's given away everything. She's going to die. She goes over the house, his house. She gets there, thanks to him providing the ride. And this is an abusive guy that she's been abused by before. She went to the wrong person for help. They proceeded, as he mentioned, for several hours. They drank some more. Well, drinking does not help a suicidal, depressed person. That's a depressant. By drinking, we're talking about alcohol. And then they get in a fight in the bedroom, and that's where he got the scratches. And yes, he was on top of her. She was on the floor, and we intend to show that through her testimony, beating her. So when she goes into the, wherever they call it, the living room, dining room combination, she grabbed that knife because she didn't want to be beaten anymore. And as you know, when I think he's over 6 feet tall and over around 200 pounds, she's like 5'4", about 150. I'm not giving away your age because I don't really know what it is, but she's small. He can whip her rear end big time, and she knows it. And she was tired of it. And so to prevent serious bodily injury is when the knife came out. But we're not talking about the knife. We're talking about the scratches. And that was in self-defense. And we're going to prove the past conduct and the rationale for her mindset at the time. And with that, I'm going to call my first witness.
Okay.
We call Jennifer Lopez. Genevieve Lopez. She's going to kick me.
All right. If you'll come forward and take a stand, please. Right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand. State your name for the record, please.
Genevie Lopez.
All right. Make sure you keep your voice up so that the court reporter can hear. All right. Defense.
I'm going to ask the court reporter to loan me some more. I've got those somewhere in my bag, the ones she gave me before, those stickers. Thank you. Minutes.
Sure.
Get these marked and we'll You can be looking these over as I mark them.
Okay.
What number did I end? 7?
You ended council on number. Defenses Exhibit 6.
6, so this is 7.
This is all one exhibit. Oh, this is.
Okay.
He's almost done.
And Mr. Steinberg, I just want us to be clear, the record to be clear. With regards to the state's request for the lesser included offense, they've just met the elements for that. You understand? So I'm not finding your client guilty of the lesser included
I
offense.
understand that now.
All right, I just wanted the record to be
You
clear.
eventually got it through my skull.
Okay, all right, thank. So it's just that they've met the elements for the lesser included.
I just wanted to make sure that I was defending against,
Sure, no problem.
and I'm looking for some offense reports that I had. Oh, I found your stickers. Hey, tell me when you're all ready on those and I'll get started. You ready now? I'll present it to them. Got it. Oh, that's okay. I don't need them in order. Now we're on 9. 10, okay. This should be 11. Well. I can proceed while y'all are looking at those. Okay. May I approach?
Yes. Yes.
Remember, I'm hard of hearing.
Oh, I'm sorry about that. Yes, you may approach counsel.
I'm showing you with the markings of exhibit number 1. On the day in question, April the 2nd. Were you very suicidal?
Yes,
Very.
very.
Were you crying and sobbing when you talked
Object
about
to leading.
the phone?
Sustained.
Yes.
Were you
Excuse
very-
me.
did
When
you
it
have
objects,
emotions?
counsel, just 1 second. There's been an objection. So the objection has been sustained. When I make a ruling, if you have a question over whether or not you can continue to answer, just ask me, all right?
Okay.
All right, so that objection is sustained. They object to leading counsel.
Sure. Thank you. Describe your emotional state. You had that conversation with Robert, the complaint, before you sent that $2,000. Will you describe it? Your emotional state?
I was,
Object to relevance about the $2,000.
All right, that'll be overruled. You can answer.
I was extremely suicidal. I was, crying, wanting to hurt myself. I believe before that, I actually, self-harmed by cutting a bit. I was in complete distress mentally.
Can you tell the court why you sent $2,000 to Robert?
Because I planned on killing myself and I wanted to give him the money for the kids, what I had left.
Did he keep the $2,000?
Yes.
Back to speculation.
That'll be overruled.
Never got it back. did you?
No.
All right, we offer evidence that things exhibit number 1.
Object, because it's hearsay. And secondly, they've written on the exhibit, defense has just handwriting on it.
What is defense exhibit number 1? May I see counsel?
Sure.
Oh. If, however you want to. All right, with regards to defense exhibit number 1, the state's objection will be sustained.
Did you? Or did you not send $2,000?
You did.
Objection to absent answer.
All right, that'll be overruled.
I've got the exhibit approach on the next.
Yes.
one. Defense exhibit number 2. March the 31st. Who said they were going to kill themselves? If anybody.
Object to hearsay in this exhibit.
Robert.
All right,
Sorry.
that objection will be sustained.
Was this directed to you
Yes.
on your cell phone?
And object to them continuing. to
All right, that
talk about-
objection will be sustained.
You still have your cell phone?
Yes.
Message is on there?
Yes.
Now. Make sure, I think. I'm not offering for the truth of the matter asserted therein that he's gonna kill himself, but that was her impression. On her mind on August the 31st, that he was threatening to kill himself.
All right, objection is sustained.
To relevance to that.
With regards to relevance, that's overruled, but the objection is sustained with regards to the previous objection made by state. Counsel, if you want to lay the foundation, the court will.
I'll lay it with him when he takes the stand. Thank you.
All right, I'm assuming we're off the record. I'm assuming he's going to call the complainant back. So if you can make sure that he's in the vicinity.
Yes, Judge.
All right. And defense, you may continue.
On March the 30th. complaint said he hated you, right?
Yes,
And he texted you to that, correct?
yes.
On March the 29th, and I'm gonna offer defendant's exhibit number 3. Where he says, listen, a text from him,
Robert,
Robert.
Or the state objects to defense exhibit 3 because it's additional hearsay. There's writing on it from defense, and furthermore, it's not relevant. Defense is telling us we're gonna see him say threatening things to the complainant say threatening things to the defendant. This is, they're saying that the complainant is saying he's going to kill himself. That's not relevant to any of the allegations in this case.
And I respectfully disagree with that. When somebody's threatening to kill themselves,
All right, may I see defense exhibit that everyone is objecting to?
Your Honor, may I approach?
Yes. All right, with regards to defendant's exhibit number 3, the state has objected to the writing that is on the document. So with regards to that, the court will sustain sustain state's objection to defense exhibit number 3.
what's defendant's exhibit number 4? Is that a picture of you?
yes.
And when was that picture taken?
March 27th.
Now, with respect to that, what does that show?
The side of my face that's swollen.
That's the end of March. What's happening? On April the 2nd. And who caused that?
Robert Courtney.
Did he hit you once, twice, 3 times? Do you know how many times?
At least 5 or 6 times.
And did you hit him before he hit you?
No, not at all.
And he's a lot bigger and stronger than you, right?
Object to leading.
Overrule. You can answer that
Bigger
question.
and Stronger than you, right?
Yes.
You had any doubt in your mind whether or not you could confront that man and beat him?
No.
You can't.
No.
And he's whipped up on you many times.
Object to leading.
Overrule.
How
I'm
many
sorry.
times has he whipped up?
Sorry, just 1 second. The objection will be sustained.
How many times has Robert whipped up on you prior to March, the end of March of 2023?
Too many to really count.
All right. Is that truly an act we could pick? Defendant's exhibit number 4.
Object to defense exhibit number 4.
All right, counsel, if you'll lay the foundation and then I will hear whatever objections parties have.
Referring to how you looked on that day, that you showed defendant's exhibit number 4. Is that truly an act to depict the result of you being hit?
Yes.
Okay, I'm gonna show you what's been marked as defendant's exhibit number 5. And all these are on your cell phone, right?
Yes.
And when were you hit then?
This was September 10th of 2020. 2020.
And who's caused those injuries to you?
Robert.
Did you cause any injury to Robert on that day?
Oh,
Remember that day?
yes,
I'm gonna show you. Okay, we offer evidence. And it's just truly and accurately represent the way you looked after you were hit by Robert around September the 10th of 2020.
yes,
We offer that evidence.
State
Show it to
objects.
opposing counsel.
State objects to Defense Exhibit 5. It's multiple photos. It's cumulative. Defense has written all over the photos. There's dates written on there. There's circles. There's things, demonstratives that have not had any foundation laid for them, and for that reason, and it also happened 2 year or a year and a half, or at least, before the offense, and for that reason, the state argues it.
All right, could I see the exhibits, please?
And exhibit number 6. That truly and accurately represents you being hit
yes,
by whom?
Robert,
And what date was that?
December 2nd, 2022.
2022. We don't have, do you have pictures of every time you've been beaten by Robert?
Ejaculating.
Overruled. You can answer the question.
Yes,
Every time you have pictures?
well, no, not every time. He's actually taken my phone and deleted a lot of previous pictures that I had took.
And on defense exhibit number 6, who hit you?
Robert,
Did you hit him?
no,
Evidence, defense exhibit number 6.
State will make similar objections to Defense Exhibit 5. It's multiple images stapled together. It's cumulative. They, defense has again drawn all over the picture, the photograph, and written dates on there that weren't already on there. They're not timestamped or anything like that.
Well, let me address the date. On these dates that are written there on your cell phone, does it have the dates?
yes,
And you just wrote the date from your cell phone onto the picture. Is that correct?
yes,
Does that truly and accurately reflect on 2022, December 20th? The result of you being hit by Robert?
December 2nd, but yes,
And the only writing was that date which you got from your cell phone, correct?
yes,
And you're saying that's true and accurate date?
yes,
And with respect to the circle around the grooves, that's the only writing on there, right?
yes,
We offer it again.
And the state will renew its objection. She's now admitted that she's asking the court to take her writing on the document to be interpreted for the truth of that matter.
Could I see?
And she did say that the photograph was timestamped in her phone, but she didn't give us a screenshot with the timestamp. They wrote everything by hand. They also said the date was the only thing written on the photo, but they've drawn all over the photo. That's on there too.
All right, with regards to state's objection to defendant's exhibit number 6, the objection will be sustained.
He was marked as a fitness exhibit number 7. To refresh your memory on what day was a threat to kill himself made.
on September 7th.
So he's
2023.
continuing to threaten to kill himself. and himself were talking about Robert.
Object to hearsay, this exhibit hasn't even been entered and the defendant, or defense counsel is trying to read into the record what's in this exhibit.
All right, with regards to statements made by, alleged to have been made by the complainant, the objection will be sustained to hearsay. And was that state's exhibit number, counsel? What number?
I believe that was 7. Let me see. That's correct.
All right, if I could see state's exhibit, I'm sorry, defense exhibit number 7, and I'll make a ruling.
And further, Your Honor, the state is also objecting that this was after the incident. And the fact that the complainant wanted to kill himself after the incident is definitely not relevant to what happened the date of the incident.
My response to the relevance, it continually happens.
All right, here's the thing, let me make my ruling. Let me make my ruling. With regards to relevance, that objection will be overruled. However, with regards to the other objections made by the state, that will be sustained. So the objection to defendant's exhibit number 7 is sustained. Oh, you're welcome.
Not thank you for the rule.
Thank you for the paper. No, you're welcome. I understand, counsel.
I'm gonna show you what the mark is defendant's exhibit number 8. But before I show it to you. Before April the 2nd of 2003. Has Robert threatened to kill you?
Yes,
Can you?
Object to hearsay.
That'll be overruled.
How many times?
I can't really give you a number,
Well, a few, rarely, many,
many.
and he continues to do that. He threatens to kill you in a text dated August the 7th
Object to hearsay.
Sustain.
on a. As Robert, prior to April the 2nd, threatened to inflict pain on you.
Object to hearsay.
That will be sustained.
In respect to that, Your Honor, we're offering for her state of mind on April the 2nd, 2003, why she felt in fear.
All right. Are you offering it for the truth of the matter asserted or no?
Fact that she was scared.
Your Honor, I would disagree. He just asked her if he made the threat, not what her state of mind was or how she felt about it.
All right, counsel, if you want to rephrase your question, you can rephrase the question, but you are allowed to ask questions regarding her state of mind.
Due to past course of conduct, verbal or physical, by Robert, on April the 2nd, 2003. Were you fearful?
Yes,
Were you fearful of serious bodily injury by Robert?
yes.
When you were in the bedroom, where was Robert and where were you?
I was on the floor and he was on top of me.
And was he not hitting?
He was.
And at that time, those scratches on Robert happened where?
In the bedroom.
In the bedroom, and there's no camera in the bedroom, correct?
No,
They were inflicted by you on Robert. Why?
because I was trying to get him off of me.
When you escape to the kitchen, you want that infliction on Robert to continue?
No,
Were you trying to protect yourself?
Yes,
And you're aware of the fact that somebody that big compared to your size hits you in your, I think it's called the orbital of your eye. Take a fracture.
Object to leading, object to speculation.
Sustained.
You're aware or you're not aware that a fractured orbital.
Object to leading, that's the same question.
All right, so timeout, stop.
Sure.
So everyone, Diana is taking the record, so she can only take it down one person at a time speaking. So he can finish his question. And before you answer, if one of the attorneys has an objection, let them finish their objection before they answer. And then I will make a ruling on that objection. Do you understand? All right, so you're going to ask your question and then state if you have an objection, you of course can make your objection.
Asking me to obey rules. So. Prior to April the 2nd. And including April the 2nd. You have fear of serious bodily injury.
yes,
By whom?
Robert.
Or when you got that knife, you wanted, and you told him, it's on the video, stay away from it.
Yes,
Did you?
yes,
And Robert, prior to, even after April the 2nd, 2000, as he told you that he desired to inflict pain on you.
yes,
Object to hearsay. And
That'll
object
be
to
sustained.
not waiting for an objection to end.
All right, that'll be sustained.
You recall October 16th of 2022,
yes,
did you see Robert that day?
yes,
And where were you?
at my house.
And what did you see Robert do? Just tell me what you saw Robert do.
Smash in my boyfriend at the time's windows.
Smash the windows to your car.
All his windows to his car, the lights, one window on my car.
And what about that rear side, whatever you call it, mirror?
The mirrors, yes,
Smashed it with.
a
looked like
crowbar,
crowbar. You saw that.
yes,
Did you call the police?
yes,
There's a picture of Bennett's exhibit number 11. Is that your car?
no, that is Anthony Mejia's car.
And was your car also damaged?
Yes,
Well. That was on October the 16th.
this is my car.
I'm sorry, you're going to have to speak up.
This is my car right here.
Okay, that's why you have a circle around there
Yes,
and it shows a smashed window,
yes,
driver's side window gone, right?
Yes,
Smashed by whom?
Robert.
And then you called the police.
Yes,
Police came. And Robert had left.
yes,
Or was in the process of leaving. They saw him leave. Then that night at your house, was Robert back?
yes,
Did he start a fire on your air conditioner?
yes, he did.
Did you try to put it out with a hose?
Yes, I did.
Did you call the police?
Yes,
That August 16th, 2022 fire, if you'd been asleep, because that was an evening, correct?
yes,
You wouldn't have put it out. It could have died.
yes, it was right.
Sustained.
I'm sorry.
The
Yes,
objection, no. The objection is sustained, so you cannot answer that.
Yeah. Did you take a picture of the air conditioner?
yes,
I'm gonna show you defense exhibit number 12. That truly and accurately reflect the damage done to your air conditioner at your house by Robert on October,
October 16th,
yes,
2022.
2022.
Yes,
Show you. Well, you already see. Defense exhibit 12.
Yes, the state objects. Defensive exhibits 11 and 12 for hearsay and the writing all over the photo.
Let me see defense
Here's
exhibits.
defense exhibit 12. All it shows is AC.
Okay,
And again, the date is from the, her camera.
all right. The court will sustain state's objection to number 12. You're welcome. Thank you.
And with respect to exhibit number 11, you've already identified Anthony's vehicle and your vehicle,
yes,
and we can delete the writing on it. And if we delete the writing on it, Your Honor, with that deletion, we offer defense exhibit number 12 and redact, scratch through that.
I haven't.
You
seen
have
it.
to remark,
You've
counsel.
already seen it.
Well, I mean, I've seen it with the writing. He's saying he can delete the writing. He hasn't produced an exhibit with the writing deleted. So as of now, I'm still objecting to his exhibit.
And I'm saying.
All right, so counsel, this is what we'll do. We're going to take a short break. You can go into the back offices and you're more than welcome to use the printer back there.
Thank you.
And you can remark those exhibits. And then the court will hear whatever objection the state has. Okay? All right, that's what we'll do.
And you reported the damage to the air conditioner to the police also, correct?
yes,
And the police have, he's now charged with that
yes.
criminal. And let's go back to April the 2nd. Do you even remember what the argument was about? Have Robert on top of you in the bedroom?
I was on the phone with my sister.
I can't hear you. I'm
I
sorry.
was on the phone with my sister and she was, we were pretty much talking about what had happened the night before on April 1st. And she was saying that we had went out downtown and he got upset because he thought that I was with somebody. He thought I was with a man. And he just got upset at the conversation that me and my sister were having.
So what we saw on those videos was after the scratches.
Yes,
And you were saying that you were defending yourself from a not only the conduct of Robert that night, but prior to
Yes,
that night.
yes,
And were you concerned when you were fighting Robert in the bedroom and he was on top of you? Was he angry?
yes,
Object to speculation.
Was he
Oh,
hitting you?
That will be sustained.
Was he hitting you?
yes,
Did he have a smile on his face?
Object to leading.
Oh, that's a question.
uh. I thought he did.
And you were trying to, I believe you said the reason the scratches on Robert were why?
Because I was trying to get him off of me.
But who initiated the physical confrontation?
Robert,
How did he initiate it to result in you being on the floor and him on top of you?
I was sitting on the floor talking to my sister on the phone. She was on speakerphone. He got upset at the conversation that we were having and he literally jumped at me on top of me.
Did you jump on him first or did he jump on you first?
No, he jumped on me. I was on the floor. He was standing up.
Okay. Yes. Okay. I think I'm going to pass the witness at this time with respect to the scratches which happened in the bedroom. As I understand, that's what we're going on today at this time. I'll pass the witness.
All right, state.
So you transferred $2,000 over to Robert that day?
Yes.
Okay, so why did Robert need to pay for your Uber to get to his house?
I was talking to him over the phone while I was at my mom's, and I was telling him that I wanted to kill myself by any means, and he said that he would do it for me. So I said, okay,
Do you have those text messages?
yes, I do.
Okay, why didn't you try to enter them today?
I did give them. I'm not sure where they're at.
So he must have lost them.
I'm really not sure.
Um, if you were so scared of serious bodily injury from Robert, why didn't you just leave once you got the knife and he moved far away from you?
Excuse me, Your Honor, we're not concerned with that. We're concerned with the scratches that happened in the bedroom, is my understanding.
All right, that objection is overruled. You can answer the question.
What was the question?
If you were so scared of serious bodily injury from Robert, why didn't you just leave after you got the knife and Robert backed way off of you? Saw it on the video.
Well, I had no way of leaving, and my intention was to kill myself. I was stabbing myself.
You were stabbing yourself?
Yes.
Where, do you have any photos of stab wounds on yourself?
No.
Okay. So how you stabbed yourself? Did you tell EMS at the scene that you had stab wounds?
Yes, I told them that I
Oh, you
had.
did?
Yes.
Okay, well, did you tell EMS that he caused any injuries to you?
I told them that he did not cause all the injuries to me. That yes, he did, but not all of the injuries that I
Which
had.
injuries did you tell them he caused?
I didn't specify.
And so if you were so scared of him, how come after he left the house, you didn't just leave and go somewhere else?
I was drunk, distressed. I initially went there because I wanted to tell my kids goodbye, and he said that he'd kill me, so I wanted to die that day.
And you said you were drunk and distressed. Do you think that could cause you to inaccurately recall how things played out that day?
Yes.
So you're not sure that what you're telling the court today on the stand is an accurate reflection of what happened?
No, I mean, I remember what happened that day.
Okay, but you just said you were so drunk and distressed, you can't accurately recall it.
No, that,
So were you drunk and distressed?
yes, I was drunk and distressed.
And do you think that may have caused you to inaccurately recall anything from that day?
No,
Okay. And you said Robert threatened to kill you many times. How come all of defense exhibits only talked about Robert killing himself? How come there were none about him threatening to kill you?
there are text messages there
Okay.
that say that he is going to kill me even after April the 2nd.
But you didn't bring any to court.
Yes, they are there.
I read them. They all say that he wants to kill himself. They don't say anything about killing him.
Objection, that's misleading statement. We showed them an exhibit where he said he was going to kill her. And we pointed out at the time that it was made subsequent to April the 2nd, but he made that same comment to her several times before April 2nd, and they objected and whatever. You sustained it, and I'll
right.
clarify that when Robert gets on the stand. But for him to say he never saw it, that was an exhibit which they objected to. He
All right.
saw it.
So if you can answer the question, you may answer the question. If you feel like the question is not one that you can answer, then let the state know. Ask your next question.
Why didn't you just get an Uber to leave Robert's house when you were in fear of your life?
I no longer had any money. I had sent him all the money that I had.
And did you owe Robert any money at any point?
No,
Okay, so the text message where he says he's forgiving your debt, that's not referencing something that where you owe him money?
no,
Okay. You said that he was upset with a conversation you were having with your sister, correct? So he got on top of you and he assaulted you and he had a smile on his face while he did it. That's your testimony, right?
Yeah.
Did you have a smile on his face when you were chasing him with the knife?
at certain points, yes, he did.
Oh, you thought he was having fun while you were chasing him with the knife?
I think he likes to see me in distress, and he wanted to show my distress, and he's laughing about it because he knows that I wouldn't hurt him.
Okay, so why would you chase him around with a knife if he knows you wouldn't hurt him?
Why did I chase him around with a knife? Stupid. It's just stupid what I did.
Have you ever chased him around with a knife before that day?
No,
Okay. And so on the day when he came over and broke those windows on your new boyfriend's car, you took pictures and you reported it to the police. How come you never took pictures and reported things to the police in any of these other incidents that you're now bringing up?
because I didn't want him to get in trouble.
And so now you do want him to get in trouble?
I mean, I wanted to be known that this has been happening. I didn't tell because one, I was scared about what he would do if I did. He's the father of my kids. I don't want him necessarily to be hurt or to go to jail or anything like that. Now I need to defend myself.
Okay, so
He obviously doesn't care.
okay, so you're just saying what you're saying now because you're trying to defend yourself. It's not because it's true, right?
No, everything is true. He has abused me over the years, over 11 years. No, I did not report any of it.
And so we watched the video and we when you were being did you ever ask for your glasses to be given to you after the incident?
Yes, I did. And my glasses were knocked off in the bedroom. when he
Okay.
was assaulting me.
Why didn't you put your glasses on, like, once you had the knife and he wasn't assaulting you anymore?
I could not find my glasses. I cannot see without my glasses, and I was trying to find my glasses and he wouldn't let me.
But weren't you chasing around with the knife just fine with no glasses on?
Yes, I guess.
Were tripping over things?
I was actually tripping over things and running into some things.
Did you trip over something when you like literally made him run out of the house when you were going up
No.
to? Did you trip over?
No.
Where did you trip?
Somewhere in the dining room or the kitchen.
Did you sustain any injuries?
I had, from the trip, no.
What about the fight with your sister? Did you get in a fight with your sister?
Yes,
Did your sister assault you?
yes,
Did your sister cause scratches and injuries to your face?
yes.
Um, and so do you remember the video where you said to your kids, you don't want to kill the kids, you just want to kill Robert? Why did you say that?
Upset that he's telling my kids what he was telling them, upset at what he was telling me.
What was he telling your kids that upset?
That I don't love them and how I don't try to get help. He told them, not on the video, but he told them that I'm a whore. He tells them a lot of things about me, especially that day.
And you think that his analysis of you running around with the knife was wrong, that he shouldn't have said anything to the kids about that?
Do I think he should not have said anything to the kids?
Do you remember, do you think that what he said was wrong, like that he was incorrect when he was saying that you running around the house with a knife kind of is bad mothering, basically?
Do I think it's wrong? Yes.
So you think that's good mothering, running after him with a knife?
No.
Can I may I approach the witness?
Yes.
You said that you told EMS about him assaulting you in the house, right?
Mhm.
Okay. The EMS, I'm just gonna show it to refresh your memory. It's the EMS records from.
Can you tell me what you're talking about?
What we're gonna talk about, oh, sorry. This page.
Oh,
No,
mark
she
that.
talks about. And I'm showing you what is marked States Exhibit 30. And it's the records from the EMS that came to see you that day. Can you show me on the record where it mentions that you told them he assaulted you that day?
At this time, we're going to object to him showing Genevieve States Exhibit 30. That's hearsay. That
It's not being
person is not
offered.
here to support that.
Nothing offered as an exhibit. She's offered contradictory testimony. This is to refresh her memory, so she can give accurate testimony.
It's still
All right,
hearsay.
defense objection will be sustained.
And when you told Robert that you were going to hurt him with the knife, what threat was Robert making to you in that moment?
Excuse me, hate to be a doofus, but I didn't think we're talking about that anymore. It's supposed to be the bedroom incident.
All right, objection will be overruled. You can answer the question.
He wasn't doing anything to really threaten me besides words.
So if you were so afraid of Robert, why were you the one threatening violence towards him after he stopped and wasn't being violent towards you at all?
The distress that I have been dealing with him. I left him in 2019. He said 2018, but it was 2019. And since then, he has harassed me countless times. I lived in my own place and he has unannounced come over to my house, barge in, want to fight me, want to see who's there. He's gone to my job.
But did he go to your house that day, or did you go to his?
I went to his house.
Okay, so even though you say that you've been abused by him for years, you have, you're afraid of him, you think he's gonna hurt you, kill you. You still went over to his house, and then the only thing we see on the video is you threatening him. How do you explain that?
Excuse me, Your Honor. Again, I'm going to repeat my objection.
All right, the objection will be overruled. You can answer the question.
So what was the question?
So you've drawn an elaborate picture of abuse from this man. But on the date of the incident, you went to his house, and the only person who is seen, the only person who has any evidence of violence is you to him. There's no evidence of violence from him to you that day. How do you explain the threats you're making in light of all that?
Objection, Your Honor. That's an incorrect statement. She testified to what happened in the bedroom. That is evidence. So that's a mischaracterization in his question.
All right, that'll be overruled. You can answer the question.
I'm not understanding the question, what you're asking.
Just asking you to explain what the threats you're making to him, given the fact that he's not threatening. And if you're saying that the reason you're acting that way is because you have this history with him, why go over there? And once he starts getting violent towards you, why not leave? Why do you remain and continue to threaten him rather than leave and protect yourself?
I didn't care what happened to me. I wanted to die that day, and I wanted to do it by any means. And if he was going to do it for me, I was going to let him.
Okay, so then why were you threatening to kill him if you wanted him to kill you?
Well, once he got on top of me and just started hitting me, wasn't actually going to kill me. He was just getting mad because he thought that I was with some man. I got the knife to get him off of me, and I said that I was just going to do it right then and there, which was kill myself.
Okay, so you were going to kill yourself. So why threaten to kill him if your intent is to kill yourself?
I don't know. At that point, like I said, I was drunk. Just, I don't know.
And you said you also didn't care what happened to you, but you also say that you were in fear of bodily injury. But if you didn't care what happened to you, why would you be in fear? Which one is it? It can't be both. Were you afraid of bodily injury, or were you in no fear because you wanted to die?
To be honest, I guess it was both.
Okay. So you were scared of him that he was going to kill you, but you wanted him to kill you. You also wanted to kill yourself, but you wanted to kill him. It seems like you just want to have it both ways on pretty much every point. Is that true?
No.
Absolutely.
Defense? Defense? Any questions?
Yes. I'm sorry, I didn't hear y'all fast.
No, it's okay.
Going back to October the 16th, when Robert came over and smashed your car's windows, including your rear window.
Ask and answer.
A
Yeah.
rule.
I'm going,
You can answer, you can ask the question.
after that, when the policeman asked you, did you desire to press charges? Didn't you say no?
Yes,
Why?
because I didn't want him to get in trouble and I didn't know what he would do after that if I did press charges.
When he came back that night and started the fire on your air conditioner, when you were asked, do you want to press charges? Didn't you say no?
Yes,
Why?
because I was scared of what he would do.
That'll
Pardon
be
me?
overruled. Stop, time out, everyone. So when an objection is made, don't answer. I need to make a ruling. And everyone else, there's one person speaking at a time. One person speak at a time. So I can make my ruling.
And I apologize if you.
I
made a ruling,
understand.
I didn't hear it.
No, I didn't get a chance to because you all are talking over each other. And if people do not want the court to make the rulings, and if you all continue to talk over each other, what's going to end up happening is we're going to recess for the day. Diana will leave, and then you all can argue amongst yourselves.
I don't want that to happen.
All right. So defense, ask your question. Once you've asked your question, state, make your objection, and the court will make a ruling.
Okay.
You may proceed. Ask your question.
On October the 16th, after your windows were smashed, did you say you wanted to not press charges?
Yes,
My question then was why?
because I was afraid of what he would do if I did.
Okay, my next question is when Robert came on October the 16th, 2022, came back to your house and started a fire on your air conditioner. And the policeman, the arson investigator asked if you wanted to press charges. You said what?
No,
Why?
because I was afraid of what he would do.
And on April the 2nd, when Robert was on top of you, were or were you not afraid of what he was going to do?
Yes,
So you were afraid of what he was going to do?
yes,
You were overmatched physically?
Objected meeting.
Sustain.
Did you consider yourself able to beat up Robert when he was on top of you?
no,
And you went over there. Did you go over there to say goodbye to your kids or not?
yes, I did.
Ask the witness.
State.
Further question, John.
All right, you may step down. Defense, call your next
With
witness.
respect to the assault bodily injury causing scratches.
I'm sorry.
We rest with respect the assault bodily injury causing scratches.
All right. State. Do you close?
Just a moment of the court's time.
State closes.
Defense, do you close?
Yes,
All right, the court will hear brief argument. State.
Your Honor, I think the testimony is unrebutted that he sustained those injuries from the defendant, the complainant. it sounds like they do have a long and colorful history together, to say the least. And Your Honor, I would even submit that maybe he has been the aggressor in other situations. But in that situation, on that day, it's very clear that the defendant was the aggressor. It's unrebutted that the defendant got an Uber ride over from the complainant, that she showed up and that she was intoxicated. She said she was having in some kind of a delirium or some excited state where she wanted to kill herself, which, you know what, Your Honor, so did the complainant in this case. It sounds like they both have some issues with regard to that. But it sounds like on that day, she showed up wanting to kill herself. You can see on the video, she's causing a lot of problems. The children are crying, they're fighting. She's chasing the complainant around with a knife. She says the reason she was doing that was because he had just gotten done assaulting her. And yet, she brings no evidence of injuries from that day. There's actually no evidence other than just, she said that he assaulted her, but she also says that she was drunk and she's kind of saying that, oh, despite the fact that I'm drunk, I remember everything clearly, which Your Honor, would say that kind of shows a lack of credibility. She can't even admit that when she's intoxicated, maybe she doesn't remember everything exactly as it seems. So she does say that he assaulted her, but once she got the knife, it's clear that she was the aggressor. And if she was scared, as she said that she was, once she got the knife and once he left the house, she could have fled. She could have called the police. She had a lot of things she could have done. But instead, as the complainant says, he tried to poke his head in and she came in and slashed him with the knife again. So it's very clear that she was the aggressor. She wasn't in really any fear. She was drunk. She also wants you to believe that she was in all this fear of serious bodily injury, but at the same time, she had no fear. She wanted to die, and that she wanted him to kill her. But also that she wants you to just disregard where we see her on the video threatening to kill the complainant. And so, Your Honor, I would submit that it's clear who the aggressor was that day. She may not have been the aggressor on other days, but she was the aggressor that day, and she did cause those injuries to a family member. The state asked the defendant kills.
Right, defense. Yes, proceed.
Howdy. With respect to the assault bodily injury causing the scratches on Robert, that's what we're here about right now. The testimony of Genevie was that she had been beaten and beaten and beaten over a long period of time. And she had photos of herself and she identified the dates when she was beaten by Robert of the photos. She didn't have photos of all the beatings. Just like on October the 16th, when he came over and smashed the windows to her car. And then he came back that night and started a fire on the air conditioner in her house. She still was afraid of him and his reaction if he got charged with a crime. This lady had lived a life of fear and intimidation by Robert. And basically what it amounts to with respect to the scratches, her testimony was unequivocal and clear that he was upset with her and he struck her first and he jumped on her and she was scratching and trying to get him off. That's what we're talking about, assault bodily injury. She was defending herself, and I don't have to prove that. The state has to disprove that, and I don't think they've disproven that. They could have, and the burden is on the state to disprove the self-defense. They could have called Robert to the stand and asked him, have you been beating this lady for years? Did you go over there and smash the windows to her car a couple months before? Did you go in there and light the air, ignite the air conditioner in her house? No. They could have disproved that, and she had every right to believe that this man is violent. He's threatened her. He's he damn darn near killed her when he lit that air conditioner afire. Yeah, she was scared. And I guess what it amounts to is on April the 2nd, 2023, when she calls, she wants to see her kid. She gave $2,000, all she had, so he could use it for the kids. She goes over because she had no money. He gave her an Uber ride, paid for it. She gets there and they continue to drink together. And then he gets upset, as he has done many times, because she's talking to her sister on the telephone, and whatever their conversation was, he didn't like it. So he jumped her and he started hitting her, and she started scratching, probably like a wild woman trying to get that man off. And we're not talking about equal size. I don't go picking on somebody that's 6'2" and 200 pounds.
Improper
'cause
argument, object to improper argument.
All right, that'll be overruled.
I don't recommend anybody to pick a fight with somebody that's 6'2" and over 200 pounds if they're 5'4" and 150 pounds. She couldn't beat that man. But did she scratch to get him off? You're darn right she did. And they didn't call Robert to disprove that. And yet he's here. He's sitting right there. They could have done that, but they chose not to, because I would have cross-examined him with irrefutable evidence of the physical infliction of bruises on her body caused by him and his anger. So have we met our burden on self-defense? I believe we have. And then all their stuff about what happened after the knife, well, you've already ruled on that. And when we started this, and I called Miss Lopez, it was to defend this time against assault, bodily injury causing scratches. And I think we've met our burden on self-defense. And I think we're entitled to to a verdict of not guilty on that portion. And again, I'm not waiving my right to.
No, I understand. And again, the court wants the record to be clear with regards to the state's request for the lesser included offense. The state did not find your client guilty of that at that time. The court wanted to be known that the elements that the state had presented had been met. All right. So state, it's your case, so you have final argument.
And I just want to address a couple of points made by defense. First off, they want you to ignore her chasing him around the house with a knife, which for the purposes of an ag assault, they may be right. But for the purpose of the self-defense claim, I think it's one of the most important facts in this case. We see that once she has the knife, we know for a fact that she has the upper hand.
Objection, Your Honor. That has nothing to do with the knife. What we're trying to right now is the assault, bodily injury causing scratches.
Speaking objection.
All right, you may finish defense, your argument.
Objection that he's irrelevant and immaterial argument with respect to assault, bodily injury, scratching.
All right, so that objection will be overruled.
So, Your Honor, I think it's one of the most important facts because we know that she has the upper hand once she has the knife. And what does she do once she has the upper hand? She doesn't try to escape the situation. She doesn't call for help. She doesn't do anything of that sort. She chases the complainant out of the house with the knife and then remains in the house. And she's still there when the police get there. And when the police finally get there, the first thing she says, I want to leave. She wants out of there because she knows that what she did was wrong. And Your Honor, I will also point to State's Exhibit 24, where she does say it was never played for the court, but she does say to the kids that she knows what she did was wrong and that she's sorry. So I don't think she can come here now and try to, she's trying to make up an excuse for what happened, but we have the facts on the video, Your Honor. And I urge you to watch what she's doing on that video, the threat she's making. That's not somebody who is in fear for their life. That's not somebody who is suicidal. That's someone who's trying to harm another person. And another person who's no longer, to the extent that they ever were a threat to her, a person who is not a threat to her, she's threatening to not only assault them, but kill them. And so I think when you watch that video, it's pretty clear who the aggressor was on that day. And for that reason, the state asked you to find them guilty.
All right. So, ladies and gentlemen, we're going to come back on Monday. And counsel, if you all will be here Monday at 9 a.m., the court will give you the court's ruling with regards to the lesser offense. The court has already informed both parties that with regards to the aggravated assault with a deadly weapon, the court is granting the defense motion for acquittal with regards to that. So Ms. Ferguson will give you a reset form tomorrow. So you need to be here tomorrow at 9 a.m. Do you understand? And to the complainant, sorry, Monday. When I say tomorrow, I mean Monday, but then I'm testing everybody. Everybody was just shaking their head like, yeah, we'll be here Saturday. Joy De Hoyos was like, yeah, okay, I'll be here Saturday. Yeah, it's good. And to the complainant, if you wish to be here on Monday at 9 a.m., you're more than welcome to be here as well. And again, that's when the court will make its ruling. If both parties will make sure that you approach the court reporter and make sure that she has all of the exhibits. All
that
right,
were
Yes, Judge.
Admitted, right?
that were admitted, yes.
Is any of mine admitted?
And then could someone have Mr. Cox here?
You didn't even. Is one of them in the paragraph? Did you ever want to that one?
Yes, no. I'm sorry. Yes, you can be excused for Monday. Oh, and if you come forward,
I need all of your offers.
All of my what?
Offer.